Hi, my name's Rich Bridgford of Bridgford, Gleason Artinian, and today I'm here to discuss with you Edison's so-called payment plan for the Eaton Fire. The cheap pay plan that Edison has promulgated is not in the interest of the wildfire victims. As opposed to this cheap pay plan, what we need is a negotiated, arm's length mediation protocol, which is what we've done in every other case with our clients, including in the Thomas, the Woolsey, and the coastal fires, and in the many other fires which they've ignited. Nonetheless, in spite of the fact that in every other case we've used a negotiated mediation protocol where a neutral, retired judge decides what you will receive, Edison has promulgated a plan which is solely self-administered, and by its own terms, there will be no negotiation. You get what they decide. This is the equivalent, in my opinion, of the inmates running the prison. The bottom line on Edison's recently announced payment program, three things. One, it's not going to result in you being paid what you're entitled to. There are a number of flaws in the program. It's formulaic, and it does not result in you obtaining the maximum damages which we will seek. Two, it will not be faster. We have a January 2027 trial date, and Edison, if we stay the course as a community, will come to us hat in hand for a negotiated mediation protocol where your values are decided by a neutral retired judge, as opposed to Edison unilaterally deciding what you get. Three, Edison can't be trusted. This is the same entity that burned down most of Malibu in 2018, large portions of Ventura and Santa Barbara in 2017, and large portions of Laguna Niguel in 2022. Despite having made $3.3 billion in 2023 and 2024, Edison failed to adopt the necessary wildfire remediation programs to prevent the Altadena fire. It failed to underground the wires. It failed to adopt covered conductor. It failed to adopt aggressive vegetation management. It failed to remove the zombie tower which caused the fire. And probably most important of all, it was too cheap on the day of the fire to power down for a few hours pursuant to a public safety power shutoff. Edison, the same entity that burnt down your community, cannot be trusted when it states that it has a program that will provide you with fair and reasonable compensation within a reasonable time. We have a January 2027 trial date. That's just over a year away. And why is that important? Because it's a trial date that settles cases, and not in January of 2027, but months before that. Based upon our extensive experience in litigating against Edison, we can assure you that their biggest complaint is they can't settle cases while they're trying to get prepared for trial. So we can expect that at least 6 months before trial, Edison will have to approach us if it's serious about settling this case. And when they do, that would be pursuant to a negotiated arm's length mediation protocol where a retired neutral judge determines how much you're going to get. I believe that the net effect of these deadlines is that for 90% of the victims, staying the course in the litigation will not only result in them receiving substantially more, but that it will be substantially faster. Don't be fooled by Edison's false promises. Only those who are willing to take steep discounts, sometimes up to 80 cents on the dollar, to participate in their cheap, fast pay program, might settle a few months before the other victims of the Eaton Fire. Edison's plan will not work for you. So what is the goal? The goal is to get a negotiated mediation protocol where your attorneys at a firm like Bridgford, Gleason Artinian, which has handled close to 12,000 wildfire victims and recovered nearly $2 billion on behalf of all of its clients during the life of its firm, are in your corner fighting for you. At the end of the day, less than 5% of our clients have ever opted into programs like what Edison is advocating here. We estimate that most victims will receive at best 20 to 50 cents on the dollars. There's one issue in particular that I would like to discuss with you regarding Edison's supposed plan, because I believe their comments have been deceptive. It's regarding attorney's fees. Attorneys exist for a reason. Regardless how you feel about attorneys, the simple fact of the matter is they add value. Aggressive advocacy on your behalf is the best way to maximize your recovery. Having handled 12,000 wildfire claims and the recovery of nearly $2 billion on behalf of all our clients during the life of our firm, we justify our existence, and we are therefore in your corner when Edison is represented by its own counsel. Edison and Pedro Pizarro have insinuated that if you participate in their plan, you'll somehow save on attorney's fees because they will pay only 10%. I want to discuss for a moment how deceptive this comment was. Under the law in California, a victim is entitled to the recovery of attorney's fees and interest as an element of their damage. That means that the money that is awarded for attorney's fees does not all go into the pockets of the attorneys. When attorney's fees are awarded as an element of damages, say 25%, we receive 25% of the 25% you're awarded. So at the end of the day, to be awarded 25% in attorney's fees is an element of your damages, puts more money in your pocket than Edison will in awarding only 10% to the attorneys. Now I want to discuss in detail some of the flaws in Edison's plan and why you will end up receiving less. Under the law, you're entitled to the cost to rebuild your destroyed premises in today's dollars with code upgrades. Instead, Edison has adopted junk science and a complex formula that when you take the time to run it, as we have, and compare it to the results that we've obtained in prior cases, it ends up paying 20 to 50 cents on the dollar or less. The second point I would make is that rather than providing you what you're entitled to under the law, the fair market value to replace all your personal property, Edison has once again adopted a formulaic response and will only provide you with 40% of the rebuild cost. Furthermore, lost in the fine print and repeated over and again in Edison's program is the fact that the offset on your damages isn't the insurance you were paid, which is what we've done in every other case. It's the full insurance limits which you have in your policy. For example, if you had $500,000 in insurance on your home, but your insurance carrier only paid you $350,000, you should only have deducted from your total recovery and cost of rebuild the $350,000 you received. But Edison's program provides that you will be deducted the entire $500,000. That means that unless your insurance company, in its sole discretion, has decided to pay you every dollar under your policy, you're going to be shorted by Edison. Finally, Edison doesn't even mention interest. Many people overlook this, but experienced wildfire counsel knows that the interest during the time in which you were displaced is a significant factor. If you lost your home and end up having $2 million in economic damages, which is a very conservative claim, you're entitled to interest at the legal rate. If that were 10% a year, you would be entitled to $200,000 a year. If you're displaced for 4.5 years, that's $900,000. Edison has not provided in its program for any payment of the very valuable interest that you are due by law on the displacement during the time which you were actually displaced. Let's talk about partial burns and what they can hope to recover under Edison's plan. We've handled many of these such cases. A partial burn case, in our opinion, is worth multiple six figures, sometimes over $1 million. Edison's program offers a mere $30,000 for what they have entitled as a minor damage case, and $50,000 for what they believe is a major damage case. This is even worse than the treatment of the homeowner burn downs. This is significantly less than it takes to address a partial burn. Now I want to address those who have suffered smoke and ash damage. Many firms do not handle smoke and ash cases. At Bridgford, Gleason, and Artinian, we have two objectives in wildfire litigation. The first is to maximize our client's recovery, but the second is to prevent this from ever happening again. We believe strongly in advocating on behalf of smoke and ash victims, because the larger the group that holds Edison accountable, the stronger the message and the greater the likelihood that they will change their behavior and quit burning down Southern California. But unfortunately, under Edison's program, there is little to no accountability for smoke and ash. Under Edison's proposal, a smoke and ash victim will receive a flat $10,000. Those of you who have suffered smoke and ash damage know that this is woefully